Andrew Rosenberg Law. Clear plans, peace of mind. Andrew Rosenberg Law. Plan it right, protect it all. Andrew Rosenberg Law. Guiding you when life gets hard. Andrew Rosenberg Law. Peace of mind, secure your future. Andrew Rosenberg Law. If you don't plan, you're stupid.
Welcome back to If You Don't Plan, You're Stupid, with Florida estate planning attorney Andrew Rosenberg. Andy helps South Florida families protect their legacy, avoid legal chaos, and make sure their plans actually work when life gets messy. I'm Shamika Rhymes, and today we're talking about one of the biggest reasons Floridians end up in probate without realizing it: how their assets are titled. The wrong name on an account or property can completely undo an otherwise solid estate plan. Hello, Andy.
Hey, Shamika, how are you?
I'm doing well. How about you?
I'm okay. I'm tired. It's been the day after Passover, and we had 25 to 27 people at the house, and I got bossed around by my wife all night, and I'm exhausted from cleaning dishes and everything else. So this is exciting to do a podcast.
Yes, I bet it gives you a break.
Absolutely.
Well, Andy, what does asset titling mean, and why does it matter so much for Florida families?
Asset titling is actually extremely important. I do tons of workshops all throughout the South Florida area, and one of the big topics in the workshops is literally called asset titling, and that's how important it is that I actually talk about it in the workshops. And it gets really confusing. And so that's why I talk about it. And unfortunately, most people don't understand it. And so that's why it's really important. But really what it is, it's how do you legally own title to an asset, right? To real estate, to brokerage accounts, to bank accounts, all these things that we try and grow and build so that we can eventually retire so we don't have to work so hard. How do you title this stuff, estate planning wise, so that we avoid the court system, or at least try to avoid the court system? And that's kind of what we talk about in the workshop. And I think we're going to talk about that today.
Okay. Well, what are some common titling mistakes that end up sending assets to probate, even when someone thinks they're protected?
Okay. So, I mean, there's a gazillion mistakes, but, let's talk about, I'll tell you what, Shamika, let's talk about assets as far as how things are titled in general so that people understand them. And then let's get into some mistakes. How's that?
Okay,
Does
that
that make
sounds good.
sense?
That sounds
Okay,
good.
perfect. So I like to talk about there's what's called joint tenancy with rights of survivorship, which sounds like what it is. And basically it's whoever survives who. So I like to give the example, Shamika, let's say that you and I, and there's a third party. So let's say three of us own an investment property together, and we own it as joint tenants with rights of survivorship, right?
Okay.
And then let's say I drop dead, unfortunately. What happens there in that situation, because of how the titling is set up, is that I lose my 33 1/3% share. It's gone. I lose it. My family doesn't get it. It goes nowhere. It goes to you two, other survivors. Now you and our third partner own the property as 50-50, joint tenants with rights of survivorship kind of thing. Got it?
Okay.
And then Shamika, let's say the partner dies. Now, guess what? You're the lucky owner because now you get 100% of it. That's joint tenancy with rights of survivorship. Okay. So now let's talk about a different form of ownership. Let's talk about tenancy, tenants in common. So let's say that you and me, and then we got this third partner, own that investment property, not as joint tenants with rights of survivorship, but as tenants in common. So now I had same facts. I drop dead. In a prior example, my 33 1/3% goes to you guys, the survivors, right?
Right.
But if it's held as tenants in common, I get to keep it. So my 33 1/3 stays with me, and it goes through probate, and it goes to my family or however I have it set up in my will or God knows whatever it is. So that's a big distinction between the two, right? Did that make sense?
It does, it does. And then I was wondering, is this property nice? Like, do we have details?
I never said that.
Right.
It's like I hear a lot from my clients. It's swampland in the middle of the state of Florida, worth nothing. But yeah, but I mean, so the impact of the titling is really important because it can cause all sorts of problems. It can cause probate problems, which I've talked about in prior episodes, but we'll go through that again. It can cause um, unintentional consequences that you didn't want with your family members, etc. There's so many things that can happen. So when you talk about titling of assets, you can own something 100% by yourself too, right? You can have a sole ownership of something. So let's say, Shamika, you own a bank account and it's in your name alone, right? That's a form of ownership, and
Okay.
you have a bank account. But when you pass away, if it's in your name alone, we're going to have probate court probably. So then the question becomes, how do we avoid this whole mess of probate court? And if we remember from prior episodes, we talked about what probate court was,
Mhm.
which is it's a court process. Going through the court process, which is expensive and time consuming and public record and all these nightmare things. And if you do all that, eventually it will go to wherever it needs to go to with your will. But what happens if we don't want to do all that? And that's why titling is so important. And people screw it up so bad, Shamika.
Mhm.
It's scary. And you know what they do? You know, the do-it-yourselfers?
Oh yeah.
They do it yourself and they do things on their own and they don't meet with someone that knows what the hell they're talking about. And they do things and it ends up being unintended consequences that are disastrous. Let me give you a quick example.
Okay.
Okay. So let's say that, Shamika, you're divorced. I don't know if you are or not, by the way. I don't even know if you're married, but
No,
we never
no, but
asked.
we can talk about my future divorce.
Okay. So your future divorce. So let's say you're divorced and you own your property, your real estate, your house. Let's say you have a house from this divorce settlement, okay? Like you got a nice house though. All right, you got a really nice house. All right, we're imagining this. So we
Manifesting.
go through this process, and you're like, you know what? It's in my name alone. I don't want to go through the courts. I'm going to put my son Jonathan on there, okay, on the deed, and that's smart.
Mhm.
That sounds smart, but that is a nightmare. And I see it every day. And here's the problem with doing something as simple as that. And this is, people are thinking out there listening, like, what the hell are we talking about? And I'm like, we're talking about titling of assets, guys. And this is why it makes a difference. And you're trying to avoid the court system by putting your son on on the real estate, which makes complete sense. But when you do that, if it's your homestead property, as an example in Florida, if it's your homestead property, you caused all sorts of problems. Number one, if your son is going through a divorce. Number one, if your son ends up getting sued. Number three, that's number two. Number three, what happens if your son is not good with investments and has to file bankruptcy? Then all of a sudden, this asset could be part of that divorce, that bankruptcy, that lawsuit. It's a disaster. That's number one problem. The second and the bigger problem, in my opinion, I mean, it's just as big, but one of the biggest problems is, let's say, Shamika, you bought this property or you got it from the divorce, you and your husband, you got it through divorce, and you got it and you paid 300,000 for this property, and it's now worth $1 million. And then you put your son on the property like we talked about,
Mhm.
and then you pass away. Well, there's a huge tax problem by doing something simple like what we just talked about, adding someone to the deed, like what you did to avoid probate court, right? You
Right.
do it yourself, you did it on your own. So now we got a $300,000 property and you passed away and it's worth $1 million,
Mhm.
right? So now we have this growth, this $700,000 of growth that happened while you're alive. If you sold it while you're alive, you would have what's called that $700,000 difference. That's called a capital gains tax. You'd have to pay Uncle Sam a percentage for the growth, right?
Right.
one of the advantages, there's not too many advantages to dying. One of them is something called a stepped up death benefit. So what would happen normally, Shamika, is you have your house at 300,000, it's in your name alone. You died. Now it's worth $1 million. And now it goes through the will or wherever it goes, and your son gets it, Jonathan, right? Because he's not on it in this situation. He gets it at $1 million. And he could sell it the next day for $1 million and not have any capital gains tax. He avoided that 700,000 of taxes. That's one of the advantages of dying, guys, is we get what's called a stepped up death benefit. Okay. There's other advantages, right?
Right.
You don't have any more headaches to worry about, right? I guess that's an advantage, right? I don't have to worry about paying for all my kids' shit that I have to deal with, right? Okay, so that's an advantage, I guess. But I would miss my kids and my grandkids and my granddog and all that. But you get that stepped up death benefit by adding Jonathan on the deed like you did in the example, because you wanted to avoid things. He lost that, and you die. That $700,000 he now has to pay that when he sells it, because he gets it at your basis, your 300,000 that you paid, because you didn't die yet. So not only is it a problem for creditor problems, it's also a major tax hit. I know I bored the crap out of you, Shamika, but this was important.
No, you did not, because now I know future child Jonathan, his name is not going on on there.
But I do see it all the time, and people, married couples, and one passes away, and they're like, well, we don't want to go through the courts. I'm just going to add my kids to this account, and they don't realize it becomes there's a lot of domino effect problems that happen with that. Especially if you got kids that are not responsible. Now all of a sudden it's a problem.
Right. So speaking of real estate, and I think you kind of mentioned a little bit about this, but I wanted to talk more about what issues come up when the deed is titled incorrectly, especially for married couples or blended families.
Okay. So first off, if you have a deed that I've seen it a lot lately, actually, believe it or not, I've seen it a lot lately with the court system. So I'll end up doing an estate plan for a client, and it might require a deed that we fix, and we have to put it into the trust, or we do a ladybird deed. We do all sorts of different deeds, and I send it to the county to get recorded, and then the county sends it back, says it's an error. We got a problem. So I'm like, what the heck? I did everything right. It's the right thing. I did it exactly how it was on the county website. And it turns out that these counties now, because of one of the advantages of all this technology, is they're going back and they realize that the other attorneys that did this stuff in the prior screwed up on the legal descriptions or something. And now they're saying it needs to be fixed. So I have to fix the problems that were done prior, or vice versa. So that's done all the time, by the way. So, and I make mistakes, not all the time, but you make a simple mistake on a deed. So there's something that you can do. So they'll let you know, usually the county, and you do something called a corrective deed. Okay. And it's taken care of, and you just do a new deed with the fix, and then you record it, and then it's done. But there are times when things are not done properly and something happens. So let me give you a quick example. Okay. We got John Jones, right? And then we also have John Jones Jr. And then on the deed, it says John Jones Jr. owns the property, and he gives it to John Jones, and then it was screwed up. It was actually John Jones Sr. that owned it, and it was supposed to go to John Jones Jr. That's a problem. It causes ambiguity, and it could be a major problem, and it could end up in court. So that's just a quick example of how something could happen. It could cause a clouded title situation. Unintended ownership situations can happen because of that. You could lose homestead if things aren't done properly on a deed. Again, we talked about, Shamika, that tax issue. It could cause unintended tax issues if it's not done correctly. So there's all sorts of potential consequences that can happen on a deed. And you may say, well, it's a deed, and it gets more complex. It does, but those same kinds of mistakes
Mhm.
that happen on the deed can happen also on your brokerage account, right? Your
Right.
bank account, etc. Because if you put someone on that account, on your brokerage account, you put your son or daughter on that account, they're going to lose that stepped up death benefit we talked about. They're going to, if they get sued, that account's not part of the lawsuit. One of the slides that I do a lot, that gets a lot of discussion on, Shamika, in my workshops, is I ask the question, should you put kids on accounts? And my answer is no. And the reason is, as soon as you put a kid on an account, you're opening up yourself to liability, because if the kid has a lawsuit going against them, if the kid is getting a divorce, if the kid is not good with finances and have to file bankruptcy, now that account that you put with your kid on there is now going to be subject to all those situations. So this is the problem that we see. This is all everything we're talking about, Shamika, is title issues, right? We've talked about title issues. Oh, by the way, I forgot to mention a key title. We talked about joint ownership, right, with rights of
Right.
survivorship. We talked about tenants in common ownership. We talked about owning something solely, right, in your name alone. There's
Right.
a special form of titling in 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 between a married couple. Okay, it's called tenancy by the entirety. So that's another form of ownership. So it's called tenancy by the entirety, and all it is, we talked about joint tenants with rights of survivorship. We talked about it with the example,
Mhm.
and what it is joint tenants with rights of survivorship between a husband and a wife, and it's a special protected title, of ownership that you can have as a husband and wife. What makes this so important, Shamika, is creditor protection. Okay.
Oh, okay.
Yeah. So let's say, Shamika, that you're married to your future husband. What's his name?
Donnell.
Donnell. Are
Yes.
you actually dating someone named Donnell?
No, but I like him on General Hospital, so we'll go with him.
Oh my God. Okay. So here, let me give you an example of how titling is really important. Okay. And I do this first day planning for my clients all the time when I'm meeting with them to figure out how do we want to do things. It makes a difference. You and Donnell own some investments, okay, some brokerage accounts, and it's held as tenancy by the entirety. That's joint tenants between husband and wife. One of you gets in a car accident, gets sued, okay, and the car's in your name,
Mhm.
Shamika, and you get sued. They can't come after that investment property because it's held as husband and wife.
Ah,
It's a special form of ownership that is protected. Now, if both you and your husband were at wrong and were sued for something, they can come after those assets. But if only one of you were to get sued for something, they could never touch anything that's held as tenancy by the entirety. So again, this is all titling of asset stuff. There
okay.
you go. And
Okay.
I hope I'm not losing the viewers.
No, I mean, I'm locked in because now I'm thinking about the things that my parents have put my name on and my sister's name.
Oh, it's done all the time.
Yeah.
Yeah, and listen, I got my son Jason's in law school. I have a very small bank account that is just for his law school account that I fund money into, and I only have a very small amount of money in there, but if God forbid something happens, that's going to be part of it. I have like $5,000-6,000 in there that I have to funnel money to him every month because he's not making any money yet, but that's a whole nother discussion. But yeah, I mean, everybody, I mean, when I do the workshops, I say, how many of you have accounts with your kids on it? And almost 80% raise their hands.
Yeah.
So it's common. It's common. But now you can see why I do a whole topic on it just on the workshop, because look at all what we've been talking about so far.
Yeah, Andy, I need to come to the workshop. As we'll talk after this because I'm interested in this workshop.
No worries. No worries.
Well, I know time flew by with this episode, but I want to thank you for breaking.
We're already done. Holy.
We are, I know, and you gave such amazing examples, so I could understand this, so I know the audience can understand it. So thank you, Andy. This was so informative.
You're welcome, Shamika. It's my pleasure. And again, um, we could do another topic on this later down the line and get into further detail and into the weeds if we need to, guys.
That sounds good. Well, thank you for listening to If You Don't Plan, You're Stupid. The way your assets are titled can either protect your family or send them straight into probate, even if you have good documents. And if you want to make sure that everything lines up the way it should here in Florida, visit rosenberglawfirm.net to get started. And don't forget to like, subscribe to the show, and share this episode with someone who might need it.
Take care, guys.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.
If